Yes, Mr Malik.
Lady and Lords, I appear for the Secretary of State this morning, who is the appellant in this appeal. Stephanie Harrison Casey and Shoshin Liu appears for the respondents.
Yes.
Lady and Lords, there are 5 bundles. There is a core hearing bundle and a supplementary hearing bundle.
Yep.
There is a core authorities bundle and a supplementary authorities bundle.
Yep.
And then there is a second supplementary authorities bundle from the respondents that was filed yesterday.
Yes, I think we have all of them. Hope so anyway.
Good.
Certainly I have 5, so that must be the right ones. Yep.
So, Lady and Lords, the principal question in this appeal is whether there is a public law obligation on the Secretary of State to issue e-visa to all those who are on Section 3C leave, so as to enable them to immediately prove their immigration status. The judge below answered that question in yes and granted declaratory relief to that effect. I shall seek to persuade Milady and Milords that the correct answer is no. In order to answer that question, the court will need to consider 2 matters. First, the Padfield principle, and secondly, the Wednesbury principle. So, subject to any observations, what I propose to do this morning is to address you on those 2 matters in turn, focusing on the law. I will then take you to relevant evidence and make some brief submissions as to its effect. And I will then take you to the judgment below and address you as to the judge's reasoning. Lady and Lords, that would cover ground 1 of this appeal and the cross appeal by the respondents. I will then address you on the second ground of appeal, which concerns Section 55 of the 2009 Act. The judge below held that in failing to provide e-visa to all those who are on Section 3C leave, the Secretary of State has acted in breach of Section 55. I shall seek to argue that the judge erred in arriving at that conclusion, and I will address you first on the law again and then on the judge's reasoning. So I'll start with ground 1 and cross appeal. Lady Lords are of course familiar with the Padfield principle. If an Act of Parliament confers discretion to a minister, there is an expectation that it would be used to promote the policy and objects of the Act. If the minister uses that discretion to thwart or run counter to the policy and objects of the Act, that would be unlawful. That comes from Padfield. I do not propose to take you to that authority. Now, in deciding whether there is a breach of this principle, the court must decide whether the exercise of discretion is inconsistent with the overriding policy of an act, as opposed to incidental benefits arising under the legislation.
Hang on 1 second. Inconsistent with the overriding policy of the Act.
Yes.
Yep.
As opposed to incidental benefits arising under the legislation. The authority for that proposition is the judgment of the Supreme Court in Padfield. I will take you to that authority. That is an example of the Supreme Court considering the application of the Padfield principle in this jurisdiction in immigration law context. If you look at the core authorities bundle, Padfield is behind tab 7. And may I take you to paragraph 10 of the judgment, which you have at page 154. So at paragraph 10.
Give me one moment.
Yes.
This is Lord Carnworth.
Yeah. So paragraph 10, under the heading Padfield, Lord Carnworth identifies the two issues: whether there is an obligation on the Secretary of State to issue a removal decision at the same time as refusing a person's application for leave to remain, and whether there is an obligation of the Secretary of State to issue a one-stop notice under Section 120 when refusing an application for leave to remain. The statute provided a discretion to the Secretary of State to make a removal decision and to issue a one-stop notice. The appellants argued that the Padfield principle placed an obligation on the Secretary of State to exercise that discretion so as to issue the removal decision and one-stop notice when refusing a person's application for leave to remain. There were two bases for that submission. The first was that the scheme of the legislation required there to be a one-stop appeal, one appeal where all relevant matters could be dealt with. If the Secretary of State refuses an application for leave to remain made by an applicant who is seeking leave as a student without a removal decision and without a Section 120 notice, the position was that the appeal would be confined to the category under which the applicant made an application for leave to remain. But if there is a removal decision and a Section 120 notice, that would have enabled the applicant to put forward any additional or other grounds in support of the appeal. So an applicant, for example, could have said that I do not qualify as a student, but I qualify as an investor. Or there are X, Y, and Z particular circumstances that the tribunal should take into account and allow my appeal on that basis. And the Secretary of State's failure to issue a removal decision and a one-stop notice, it was said, were inconsistent with the one-stop policy of the legislation. The second argument was that the failure by the Secretary of State to issue a removal decision and a Section 120 notice takes away from the applicant something that is of significant value, namely the applicant's ability to raise new points in the appeal. And the argument was partly premised on Section 3C of the 1971 Act. If you go to page 157 of the bundle, and if you look at paragraph 21, you'll see that Lord Carnworth there quoted Section 120 of the 2002 Act. You will see that word may was used in that provision. The Secretary of State or an immigration officer may, by notice in writing, require the person to state additional reasons. So discretion. If you then look at paragraph 24, where you have the relevant statutory, paragraphs 23 and 24, where you have relevant statutory provisions as to removal decisions, there was a discretion under the 1999 Act to issue a removal decision, and also under the 2002 Act, word may is used.
Sorry, 2002 Act.
Sorry, 2006
Six Act, isn't it?
Yes, this is, my apologies, yes, paragraph 24. So word may is used. There was a conflict of authority at this court's level. There were two judgments of this court saying that Padfield required the Secretary of State to exercise that discretion in every case, so to issue a removal decision at the same time as refusing leave to remain along with a Section 120 notice. And then there were two other judgments arriving at an opposite conclusion. And the task of the Supreme Court was to resolve the conflict in the authority. Now, if you go to page 159, and if you look at the quotation at paragraph 27, this was from the judgment of Lord Justice Stanley Burnton in this court, making the point that the language of the statute was of discretion and it was not open to the court to construe it as imposing a duty. And to do so is to amend the legislation, not to interpret it. And this was the context in which the Padfield argument was considered at paragraph 28. So what Padfield principle is set out between D and E. No controversy, no dispute about it. If you then look at the text between E to F, it was said that it can no doubt be said that one, not the overriding, but one of the purposes of the 2002 Act was to reduce the scope of repeat appeals. And the legislation leans in favor of one-stop appeals. That's the first point. The second point is in the next sentence, that if the Secretary of State exercises the power in the way that the applicants argued, then that would provide a range of favorable outcomes for the applicants. So paragraph 29 is the conclusion that neither such general observations nor incidental effects can be translated into an overriding policy, and this is the phrase that I picked when I opened my submission, requiring the Secretary of State to act in a particular way, nor into a right for the appellant to insist that he does. Incidental benefits are not enough. The task of the court is to ascertain the overriding policy of the legislation and decide whether the exercise of discretion is inconsistent with it, focusing on the language of the legislation. So this is the principle that, in my respectful submission, the court will apply when ascertaining the overriding policy of the Immigration Act 1971, the 2007 Act, or the 2014 Act. Now, with this principle in mind, may I respectfully take you to the relevant statutory provisions, and I'll take you through them in a chronological order. So first, the Immigration Act 1971. You have that in the core authorities bundle behind tab 1. Section 1 sets out general principles. Subsection 1 says that those who have a right of abode are entitled to reside in the UK. And subsection 4 refers to the rules laid down by the Secretary of State as to the practice to be followed in the administration of the Act for regulating the entry into and stay in the United Kingdom persons not having the right of abode.
Can I just ask on section 1, subsection 1, the phrase without let or hindrance?
Yes.
Does that qualify the whole of that section, live in and to come and go into and from the UK without let or hindrance?
Yes.
Not just coming and going.
That's right. So if you have a right of abode,
you can live here without let or hindrance.
Yes. Yes.
Okay.
But if there is no right of abode, then subsection 4 empowers the Secretary of State to formulate, in fact places an obligation on the Secretary of State to formulate rules to regulate entry and stay in the UK. Now if you then go to page 5, you will see section 3. Now this is the provision pursuant to which the Secretary of State grants a person leave to enter or remain. Now that leave can be granted under the rules or outside the rules, but this is the source of the power to grant leave. And you will see that subsection 1b says that where the Secretary of State grants leave to remain, that leave may be granted for a limited or an indefinite period. Now, what the statute does not tell us as to how someone would evidence that grant of leave. For example, it does not say that, well, grant of leave is to be evidenced by way of a stamp in the passport or a sticker on one of the pages in the passport, or by way of a separate letter or card or an electronic document and so on and so forth. So those matters are left entirely at the Secretary of State's discretion.
Well, so far as express power is concerned, that's true.
Yes.
Clearly, there would be arguments which, not quite the same, but analogous to the arguments we're having to consider here, that it's inherent in the concept of the grant of leave that it must be documented in some way.
Yes. There is actually a provision that, I'll take you to that in due course, that deals expressly with notice in writing.
Yes.
With grant of leave. Absolutely. So this is the point. I mean, this is implicit. The power to choose between a stamp or a sticker or a card is implicit, entirely accepted within the statute.
Well, hang on. I wasn't putting quite that. I was floating. There was an implicit obligation to evidence it in some way, and you were saying that the choice of way in which it should be evidenced was left with the Secretary of State. But do you accept the underlying proposition that it's implicit in the concept of a grant of leave that the person granted leave should be granted some evidence? Yes.
So, no. With respect to Lord, it's not simply implicit. So when the Secretary of State grants Section 3C leave, the statute places an obligation on the Secretary of State.
I see.
To issue to evidence that.
You're coming to that. Okay,
yes.
Well, there we are. Thank you.
Obligation on the Secretary of State to evidence it, absolutely.
But it's a separately stated obligation, which we'll look at in a minute. Yep.
Yes. So that is Section 3 leave. Now, if you look at subsection 2, this is the provision pursuant to which the Secretary of State formulates immigration rules. The rules are statements of the Secretary of State's policy. Subsection 3 says that where a person has limited leave to remain, this is Section 3 leave, a person who is granted leave under Section 3(1)(b), that person may apply for variation of that leave. That person can ask the Secretary of State to grant further leave to remain. And then subsection 4, where a person has Section 3(1) leave, then that person is allowed to travel. He is entitled to leave the country and come back as long as he comes back within the period of leave.
Hang on, so, this is subsection 4, I'm just being
Yes.
slow. A person's leave to enter and remain in the UK shall lapse on his going outside the common travel area unless... It's rather opaquely written, or perhaps I'm just being slow. You're saying that means that that the effect of that is that he can leave, is that right?
Yes, and come back. So if you have leave to remain until 2027, you're allowed to leave the country, you're allowed to come back without obtaining a fresh leave.
Yep.
That is the effect of this provision.
Whereas if you came back in 2028, your leave would lapse.
Yes.
Yeah. No, sorry, now I read it properly. That's obviously right.
Yes.
Thank you.
Yep. So what one gets from this particular provision is A, that it is the Secretary of State who grants Section 3 leave. Secretary of State exercises the function. There's an express bar to grant leave. B, where a person has Section 3(1) leave, that person can apply for further leave to remain. And C, that person is entitled to travel at their will, as long as they come back within the period of leave.
Yeah.
Now, then go to page 10. You'll see Section 3C. And the reason why I made the 3 points that I have made is to illustrate the difference between Section 3 leave and Section 3C leave. Now, contrary to Section 3(1) leave, if you look at Section 3, you'll see that the Secretary of State exercises no function. The extension under Section 3C is automatic. The Secretary of State has no discretion. As long as a person makes a valid application for leave to remain before the expiry of leave, and Section 3 leave expires without the application being decided, then leave is automatically extended under Section 3 subsection 1. And the leave will remain extant as long as the application is pending, or an appeal is pending, or an administrative review is pending. This is subsection 2. The Secretary of State exercises no function, it's automatic. Now, if you go to page 11 on the next page, and if you look at subsection 3, so unlike Section 3(1) leave, if someone's leave is extended under Section 3C, that leave automatically lapses if the person leaves the country. This is subsection 3. So if an applicant had Section 3C leave until 1st of June 2025, an in-time application is made, that application is not decided, leave is automatically extended, but as soon as that person leaves the country, that leave comes to an end. There is no entitlement to return. Then if you look at subsection 4, unlike Section 3 leave, it is not an option for a person on Section 3C leave to make an application for further leave to remain. That is expressly excluded by subsection 4. So if you have Section 3(1) leave, you can ask the Secretary of State to extend it. If you have Section 3C leave, you may not do so. And any application that a person makes when that person is on Section 3C leave is a void. It's an invalid application by operation of the statute. So there are these are three fundamental differences between Section 3(1) leave and Section 3C leave. And then just to address the point that Lord the Vice President made, if you go to page 13 of the bundle, you will see section 4. Now this is the fourth key difference that the statute makes between section 3 leave and section 3C leave. If you look at section 4, now this provision places an obligation, an express obligation on the Secretary of State to issue notice in writing when granting section 3 leave. The power to exercise the power to grant leave shall be exercised by notice in writing. If there is no notice in writing, there is no valid leave. But you'll see that extends only to section 3 leave. So the legislation requires the Secretary of State to issue notice in writing when granting leave, but it does not require notice in writing when a person's leave is extended under section 3C. Although this provision requires the Secretary of State to issue notice in writing, well, it does not specify the format of that notice. It does not say whether that would be a stamp on the passport or a sticker or a card or a separate letter, whether the card should be green or whether the card should be blue, etc.
I had a feeling there's some secondary legislation about that, but maybe not. You would know.
Well, there is secondary legislation.
Even apart from the rules.
Yes.
I meant, yes, there's some statutory instruments. Yeah.
The notices, regulations that my Lord have seen on other occasions.
Probably, I've forgotten, but you will remember.
Yes, but the point, my Lord, is that the notice in writing could be a stamp in the passport, could be a printed A4 paper, could be an A5 paper.
But classically, with any of the main visa routes, it would be a stamp in the passport, wouldn't it? Not anymore.
Yeah. So in early days, immigration officers would place stamp in someone's passport when granting leave.
Yes.
That practice then changed 20 years ago to the practice of placing stickers instead of stamps.
Oh, I see. I'm so sorry. Yes, I did. I wasn't distinguishing stamps and stickers, but it would be in your passport.
In the passport.
That's how a visa is. It's something which either is stamped or stuck in.
Yes.
So it's a permanent part of your passport.
In the passport, yes. And then came the regime of residence cards.
Yes.
And in some instances,
but that was really only that was an EU concept, wasn't it? The residence card, or
well,
not necessarily.
Yes, the source was EU law, but it was then extended to a number of other categories.
Okay, well, I'm distracting you. Yes. The important point is the one you have made, that Section 3 must be granted by notice in writing, which typically, but not invariably, will be by something in the passport. Whereas 3C leave, of its nature, because it's automatic, will not generate a document.
Yes. Yeah. So no obligation under the statute.
Well, in a sense, yes, the statute couldn't. The statute could create an obligation, but it would not, unless you rewrote the whole thing.
Yeah.
The obligation would be to produce a document which evidenced something that had happened already automatically.
Yes.
And that's really what we're talking about in this case. The 3C leave is never going to be created by a document because it happens by operation of law.
Yes.
Yeah.
Yes, but the point, my Lord, you have the point that Parliament could have said that when a person's leave is extended under Section 3C, the Secretary of State shall issue a notice in writing, as Parliament has said in relation to Section 3.1 leave.
Yes.
Have these provisions under Section 4 been affected by the digital revolution?
Yes. So notice in writing, in traditional sense would be a notice written on a piece of paper, printed and sent to the applicant in post. But it could be an email or something written in writing that is communicated electronically. So absolutely. So it could be. It is affected by what has happened over the last 10 years. So it could be a digital document.
But a digital document is capable of being amended, whereas a hard copy document isn't. A hard copy document, it can be amended, but it has to be amended by issuing a separate document. Once issued, it's frozen in time. I'm simplifying, of course. Whereas a digital document is capable of instant amendment. It's a different concept altogether.
Well, it depends on what sort of document my lord has in mind. If it's an email that is sent to an applicant saying that you have been granted leave to remain, then that is not very different from...
Yes, you're not really, exactly. You're not... it's the term digital is perhaps misleading. For these purposes, email is more like paper.
Yes.
Yes.
What my lord really means is some accessible online record which can be updated minute by minute.
I'm using it in the
e-visa.
In the master, the role's purest sense of digitised document.
Yes.
Not a digital version of a written document like an email, but a digital, fully digitised document.
So that shows a person's status in real time.
Yeah.
Absolutely. So the Secretary of State issues a notice in writing that is a live document in that sense that would meet the obligation under Section 4 if the Secretary of State can then vary that document to extend leave to remain, etc., and that would be another notice in writing.
Well, can we just, I don't know whether this will be important or not. Clearly, as you say, an email will be noticed in writing. Writing doesn't have to be on paper.
Yeah.
Whether it would be noticed, suppose, and you may begin to tell us this is actually how the new e-visas work, because I haven't really grappled with this, but suppose you are from the start granted a visa which merely takes the form of a statement on the government website, which is always accessible, but is not sent to you,
Yes.
like your driving license, like your car registration, what I mean, you want a MOT, like your MOT certificate. You don't get anything at all, but you can always go online and look and see what it says.
Yeah.
Now, would that be noticed in writing?
Entirely.
Well, you say that's just the natural meaning of notice in writing, or has there actually been legislation clarifying that?
So what happens in practice is that the Secretary of State would email the applicant saying that, well, you have been granted leave to remain.
Yes.
Now, that would be notice in writing.
Yes.
And the applicant can then see the status online.
Yes. So the email would say, "We have granted your application."
Yes.
And any bells and whistles, and then somewhere in that letter it would also say, "This will be evidenced, or this will be recorded online, and it will always accessible at such and such a site, which the world can see."
Yes.
Not just you.
Yes. So the notice in writing would be the email.
Yes.
But that practice.
And in the real world, that you'd always thinking it through. You'd always have to have that, because otherwise you wouldn't know
what's happening. Yes.
At what point the online record had been created. Yes, I see. Okay.
So that is the fact. I mean, it may change, but of course that isn't an issue before the court. But
no.
that is how.
Thank you.
A notice is given. Yes.
Well, perhaps we'll come back to that. I'm intrigued by how digitisation has affected this whole area.
Yeah.
And so many other areas, but I don't want to distract you.
Shall we, as my lord says, let's come back to that later.
Yes.
Sorry, Mr. Mallet was responding to was hesitating because I was smiling. I'm sorry to distract you.
Yes. So this is the relevant provisions in the 1971 Act. There are two authorities on the 1971 Act that I will take you to. The first is the New London College judgment that relates to the incidental and implied bars under the provisions that I've just shown you. And if you have the core authorities bundle, that is tab 6. That was a case where there was a challenge to the system of sponsorship introduced by the Secretary of State when the points-based system was introduced. So in order to qualify for leave to remain as a student or as a skilled worker, a student must be sponsored by an educational institution that has a sponsor license, or an employer must have a license. Now, there was nothing in the rules or primary legislation, secondary legislation authorizing the Secretary of State to set up the system of sponsorship licenses. And the issue before the Supreme Court was whether that meant that there was no statutory basis for the system and it was therefore unlawful. If you go to page 138, you'll see that the principal submission that was made by the appellants to colleges was that the system fell outside sections 1.4 and section 3.2, and there was no power to have that system at all. That submission was addressed at paragraph 28. Lord Sumption made two separate points at paragraph 28. The first point was that, well, irrespective of what the primary legislation says, the Crown possesses general administrative powers to carry on the ordinary business of government that do not require statutory authority. But we are not in that territory. The second point is made right at the end of page 138, where Lord Sumption says that that question, the extent of the Crown's administrative powers, does not need to be resolved on these appeals, because the statutory power of the Secretary of State to administer the system of immigration control must necessarily extend to a range of ancillary and incidental administrative powers not expressly spelled out in the Act, including vetting of sponsors. So the incidental administrative power under the provisions that I've shown you allows the Secretary of State to evidence grant of leave by placing a sticker or a stamp or issuing a card or issuing a digital document, e-visa.
Well, is that the correct analysis? If you are granting a visa, you have an express power to do so, not only a power but an obligation to do so in writing.
Yes.
The choice for that writing to be by a sticker in the passport,
Yes.
I agree, is discretionary, but the power is expressed. It's not incidental and ancillary. It's actually a power stated by the section 4 itself.
Yes. So that, of course, I
Section 3C for Section 3 leave.
for Section 3C, for Section 3
For
leave,
3
absolutely.
leave, yeah.
So
Yeah.
the power to grant leave by notice, or the obligation
Well,
to
it's a
grant
duty.
leave by notice, is Section
Yes.
4.
Yeah.
But how, there is then a secondary question for the Secretary of State as to how that grant is evidenced in writing, whether
Well, what form the writing takes.
yes, whether
Yes.
it's
No, well, that I accept.
okay. So that's
But that isn't quite the point. I mean, that's obviously right with respect, but it's not quite the point that that's not really analogous to the kind of issue in New London College, there where they were setting up a whole system
yes.
for the vetting of sponsors, for which there was no freestanding, for which there was no express statutory basis.
But there might be an analogy in relation to evidencing Section 3C leave, where there is no duty to...
Yes, I was just about to come
Yes,
to
I
that.
see.
Yes.
Yeah.
So when you're granting Section 3 leave, you have an obligation to issue notice in writing, but a range of administrative options as to the format of that notice, whether it would be a written document or a digital document. But when it comes to Section 3C leave, as Lady Lords has seen, there is no obligation under the statute to issue a notice in writing. But the Secretary of State has, even for those who are on Section 3C leave, in some categories, set up facilities that would allow them to consider or to access their status online. So a person who makes a digital application for leave to remain to the Secretary of State, the Secretary of State grants that application, issues an e-visa, and e-visa appears online. That person makes an application for further leave to remain. There is no obligation on the Secretary of State to issue any notice in writing that his person's leave is extended under Section 3C, but the online status would show that a person has applied for further leave to remain.
Yes.
That person's application is pending, and therefore that person is on Section 3C leave.
Yes.
The power to do that, to issue an online document recording a person's Section 3C status, is the incidental administrative power.
Perhaps I'm just quarrelling with your terminology. It's not really helpful to regard it as issuing an online document. It's maintaining an online record, an accessible online record of the progress of the application.
Yes.
Yes.
Yeah. So previously, the record would be in a physical file or in the computer systems used by the Home Office.
Yes.
What has happened is that what was on the computer systems is now placed online for everyone to see.
Yes.
Now, there is no express power to do that under the Act.
Yeah.
But that is an incidental administrative power. That is something that the Secretary of State can do.
Yeah.
And the question is whether there is an obligation on the Secretary of State to do that. So that is Lord Sumption. Look at the judgment of Lord Conworth, page paragraph 33. And he took the view that the bar derives from section 1.4. This is page 140, paragraph 33, against letter B. Whether it is section 1.4 in particular where the power is implicit, or whether it is section 3 or the Act read as a whole, it makes no difference ultimately.
So Lord Sumption's is the majority ratio.
Yes.
Yes. It doesn't really matter. I mean, you're right to show us. It doesn't really matter anyway, does it? I mean, the point is that there is a power, whether it is on the more general principle identified by Lord Sumption about ancillary and incidental administrative powers, or the more specific hook of section 1.4. Sorry, is it section 1.4? Yes, section 1.4. It doesn't really matter.
No. Okay. So this is New London College. The second authority on the 1971 Act that I'll take you to, that deals directly with section 3C, is this court's judgment in Akiniola, That is behind tab 9 of this bundle. So this court considered the circumstances in which a person's leave is extended under Section 3C and the benefit that that provision brings. If you go to page 223 of the judgment, you'll see a heading, General Discussion of the Main Issues, just above paragraph 39. And you'll see that the purpose of Section 3C is identified as common ground at paragraph 40. The purpose of Section 3C is to protect the immigration status of those with existing leave who have applied for variation of that leave and are awaiting a decision of the Secretary of State or are exercising appeal right in respect to that decision. Nothing more than that. The purpose, that is the only purpose. It is not the purpose or the overriding purpose or overriding policy of that section that those who are granted leave to remain should also be issued with a written document or a digital document enabling them to immediately demonstrate their status.
Well, that's what you're asserting.
Yes,
but it's not necessarily right. It could be said that if it is the purpose to, in general terms, protect the immigration status, it's necessarily implicit in that they should be able to demonstrate that immigration status in order to be able to establish that they are not here unlawfully. Couldn't that be said to be an implicit part of the purpose? It would have to be necessarily implicit, but couldn't it be said to be necessarily implicit?
Well, I should seek to persuade my lord that it's not even implicit. But a better point that is available to me is that even if it is implicit, I've shown you the Supreme Court's judgment in Padfield. Padfield kicks in only where the Secretary of State is doing something that is inconsistent with the overriding policy of the Act.
Yes.
Something that isn't even expressly stated or something that is so implicit that in the way that my lord puts it.
Hang on 1 second, I just want to write that down.
How again precise did you put it? Just say that again.
Well,
The override.
well,
How do you express the overriding policy precisely?
well, it is not the overriding policy of Section 3C that those who are on Section 3C should be granted a written notice of the extension of leave. The policy of Section 3C or the purpose is to ensure that those who have Section 3C leave are not overstays. If the Secretary of State comes up with rules or secondary legislation saying that, well, if you make an application for further leave to remain, that application is pending, but while that application is pending, you will be regarded as an overstayer.
Just that? Or do we have to consider the disadvantages of overstaying as identified in this judgment and the judgments cited here?
Yeah. Yes. So, I'll come to that obviously. I mean, those disadvantages arise from subsequent legislation, the 2014 Act, and I'll address you, of course, on those. And if you look at paragraph 40 Lord is absolutely right that those consequences are summarized. But can I just ask you to look at paragraph 41 that may assist. Now, one of the benefits of an extension under section 3C is that a person may qualify for indefinite leave to remain on completion of 10 years in the UK. And the period that a person spends on section 3C leave counts towards the period of lawful residence. So the incidental benefit that a person gets is indefinite leave to remain in due course, but that is not the purpose of section 3.
So you're simply using that as an illustration of an incidental benefit.
Yes. So, yes, so an incidental, that is an incidental benefit. If, for example, the Secretary of State formulates a rule in due course saying that I'm going to exclude the time that someone has spent on section 3C when calculating 10 years continuous lawful residence for the purposes of deciding whether you should be granted leave, that wouldn't be inconsistent with the purpose or the scheme of section 3C.
How would you summarise? So just how do you again summarise the policy of section 3C?
Well, the policy purpose of section 3C is to protect immigration status of those with existing leave who have applied for further leave to remain. Paragraph 40 of this judgment, that is the purpose of the Act. The purpose is not that those individuals should have a notice in writing, as section 4 says. So the purpose of section 4 is that those who are given section 3(1) leave, the purpose is that they must be given a written notice. You do not have a parallel statutory provision that concerns section 3C, so it's not the overriding policy of section 3C.
But in order to protect the immigration status
Yes.
of those existing leave, do you have to protect all the incidental rights and benefits that flow from that status?
So this is the point that I was trying to make, that if a person who is on section 3C leave has access to online e-visa, that brings or that could bring a number of incidental benefits. But those incidental benefits do not transpose into an overriding duty on the Secretary of State issue e-visa to everyone who is on section 3C. This isn't, in my submission, very different from the argument that is being made in Padfield, that issue a removal decision, issue a one-stop notice, because I'm going to get substantial benefit, I will be able to raise new points to the tribunal.
Well, I think it follows from that you say that Ms Harrison has to put it as high as being that the existence of the section 3C right necessarily, as a central part of the purpose, involves demonstrability, if I can call it that, as well as the existence of the right. And not just demonstrability, but demonstrability in this particular form. And one of the questions clearly we'll be exploring with her is whether she says that was so as far back as 2014 when the hostile environment policy was first introduced.
Precisely.
When safe to assume that the kind of digital demonstrability was not at that point technically available.
Absolutely. And issuing of a written document, and I'll come on to that in due course, issuing of a written document saying that someone's leave is extended under section 3C is impossible. It's practically impossible, because if the Secretary of State if someone's leave is extended today and the Secretary of State issues a notice that your leave is extended under section 3C, well, that notice in writing would only be valid for that point in time.
Yeah, but that's how digitisation has changed the landscape. Because digitisation enables the instant cancellation.
Absolutely.
So it's no longer an open-ended.
Certainly, as I read the judgment, I think the judge accepted.
The judge accepts that
If
one,
you're
yes.
just talking about a physical
A digital
document.
Yes. If we're having this appeal,
Yes.
you know, back in 2020, you know, pre-COVID, you know, there wouldn't be an argument that there is no
Yes.
obligation to issue a notice.
Well, here in due course, Saracen disagrees, but I don't think she does, reading her skeleton. And indeed, there would have to be a respondent's notice on this point, because the relief that he was granted was a declaration specifically about e-visas.
Yes.
That the obligation was to issue e-visas.
Yes.
Yeah.
Absolutely. So that's that. Now, there is a second purpose of Section 3C, and that purpose is identified at paragraph 42. And that is an important purpose, which is to prevent abuse by successive applications. Consider a position where a person makes an application.
Just hang on 1 second,
Yes.
sorry. Sorry, just before you get to Section 14, in fact, it's a little bit more complicated even than going back to 2014 when the hostile environment policy was introduced, because 3C itself predates
Yes.
hostile environment policy. The absence of immediate demonstrability was a problem from inception. It just wasn't so acute. But for example, there were circumstances in which you would still wish to show
Yes.
that you had, for example, if there was some police inquiry and you were going to be prosecuted for being here illegally, because that's always been an offence, hasn't it? I think.
Yeah.
I can't remember
No.
what I can't.
Yes.
But well, we'll explore all this later. But I just, since I got into the question of
Yes.
flagging up 2014 as a time to test it by, it might actually be you'd have to test it by a position even earlier. That's to say whether the Secretary of State was unlawful in not offering instant demonstrability.
Yes.
Yeah, there we are. Sorry, thank you. Carry on. You were taking us to paragraph 42.
Paragraph 42. So, second purpose of Section 3C is to prevent abuse by successive applications. So, contemplate a situation where a person who has limited leave to remain makes an application for further leave to remain to the Secretary of State. While that application is pending, in 8 weeks' time, he puts in another application, and then another application, and then another application. That person's stay would be extended for an indefinite period. And Section 3C is aimed to prevent that abuse by subsection 4, which says that it's just not possible for a person to make an application for further leave to remain when they are on Section 3C leave.
So you really have to put all your eggs in one basket. You either have to you have to decide what the basis of your application is before your previous status expires, whether it's an extension on the same basis or a different basis, and then you're stuck with that until that's decided. And when it is decided, you will by definition be an overstayer.
Yes.
Yes, this is a well-known feature.
Of course. And I've taken, of course, only to the relevant paragraphs in Padfield, but that was the sort of premise of the argument that, well, I've made an application for leave to remain as a student. I'm now on Section 3C leave, and I therefore cannot make an application for leave to remain as an investor. That's just not possible. For that reason, the Secretary of State should issue a one-stop notice or a removal decision
Yes,
to
quite.
enable me to make that point at the
Yes.
tribunal.
Yes.
It was argued that that was sort of inconsistent with the scheme. So that is the second purpose of the 1971 Act. So these are the two authorities that, in my submission, are relevant on the 1971 Act. The next piece of primary legislation that Maladian Lords will look at is the UK Borders Act 2007. So if you look at the supplementary authorities bundle, you have the 2007 Act, the relevant provisions behind tab 4.
Yes.
Now, section 5 is not, I respectfully emphasize, is not about grant of leave to remain. It is about the Secretary of State accessing biometric data of an applicant, namely fingerprints, photographs. So it was possible prior to that act for an application to be made without the applicant providing the biometric data, biometric information to the Secretary of State. The Secretary of State, the Parliament in 2007 decided that the Secretary of State should have biometric information of those who are granted leave.
Yep.
And the purpose is that this provided a discretion on the discretion to the Secretary of State to issue regulations requiring a person to apply for a document recording biometric information. Biometric information is fingerprints and photographs. Now that document could be a physical document, it could be a digital document. Indeed, section 15 provides that, makes that clear, that it could be a physical document or a digital document. But what sort of document it should be is left at the Secretary of State's discretion. If it's a physical document, whether it should be on an A4 piece of paper or whether it should be a small card, the color of the card should be red or green. If it's a digital document, whether it should be emailed or whether it should be online, that is left at the Secretary of State's discretion. But the fundamental point that I make, in anticipation of what Miller and friends would say, that this is not about grant of leave at all. This is about getting biometric information. The regulations made under this provision are behind tab 6. And if you're looking for a definition of e-visa, you'll find that definition in the regulations. Tab 6, the 2008 biometric regulations. If you look at regulation 2, it has certain definitions.
Sorry, just one moment.
Yes. Page 14, you have the definition of biometric information. This is the phrase that is used in the Act. Biometric information means...
So sorry, I'm just making a note. Which page are we on?
Page 14, tab 6.
Yep.
Regulation 2.
Yep.
The second definition, biometric information means photographs or fingerprints.
Yep.
So that is what section 5 of the 2007 Act is all about. So that is biometric. A card, a biometric card, this is the first definition, means a card which forms part of biometric immigration document. Biometric sticker means a sticker which forms part of biometric immigration document. So these are various options, administrative options available to the Secretary of State. The definition of an e-visa is on the next page, page 15, towards the middle of that page. E-visa means an online record of an individual's immigration status and conditions of leave to enter or remain.
Yes, so in fact, by chance, I was right to make a distinction between a document and an online record. The draftsman treats them as different things.
Yes.
Yeah.
So e-visa is an online record of a person's status, and I'm sure there will be another appeal in 12 months' time as to whether whether online document is sufficient for the purpose of
Well,
section 4.
let's not aside points we don't have to.
Yes.
Yep.
So that is the definition of e-visa, but my lord is absolutely right that the legislation makes an express difference between a biometric card, biometric information sticker, and e-visas. So e-visa is something different from biometric information or biometric card or biometric sticker. Regulation 3 says that a person who is subject to immigration control, this is page 16, must apply for a biometric immigration document. That could be
Sorry, again, just I dropped behind. Which page, which paragraph?
Regulation 3,
Yes.
page 16.
Yes.
So this,
one.
yeah. So where a person is making an application for further leave to remain, in certain circumstances, that person must apply for a biometric document. That could be a card or a sticker or a digital document, as long as the two conditions, one of the two conditions is met, and one condition is that the person makes an application for leave to remain. So the scheme that was introduced in 2007 is that if you are in the country and if you are applying for further leave to remain, you must give your fingerprints to the Secretary of State, your photographs, and make an application for that purpose. Finally, if you go to page 23, you will see Regulation 13. There is a discretion on the Secretary of State to issue a biometric immigration document to a person who has applied in accordance with the Regulation 3 that I've shown you. Where the Secretary of State has decided to grant leave to enter or remain. Now, a biometric immigration document, as I said, could be a digital document, but this, the court can be absolutely certain, has nothing to do with Section 3C, because the discretion to grant that document only comes in where the Secretary of State decides to grant leave, that is Section 3 leave. It is not the Secretary of State that decides to grant Section 3C leave. So this does not apply to those who are on Section 3C leave. So this is, for that reason, I submit respectfully, not the source of the power to grant e-visa to someone who is on Section 3C leave. And if you look at 1A, this was added earlier. This was added in 2021, that the reference to a biometric immigration document includes allowing the person to view their biometric immigration document electronically.
Sorry, where do we see that?
This is 1A, 13.1A.
So 13.1A just says, may issue a biometric immigration document where he's decided to grant.
No, my apologies. It's 1 capital A.
Oh, 1 capital. I'm so sorry. Oh, I see. Yes, right. Sorry. That's what was added in 2021.
Yes. So where
just so I got the dates, when was 13.1 little a added? We can see that too was added. I can probably follow up the note, can't I?
Yes, it's
2025.
2025, yes.
So in fact, since the dates to which we're concerned.
Yes.
Well, sorry to be a nuisance. Probably this won't matter for any of the material provisions, but we surely must look at the version of the regs that was in force at the time of the, well, I don't know, the judge's order, no less than the judge's order anyway.
My submission is, this fact is that there really is no need for the court to look at these at all. I'm just taking you to this in fairness to my learned friend and
yes,
with the benefit of
I'm sorry to
discussions
make
that we
difficulties.
had.
I take your point. This is secondary and defensive that we're looking at this. Nevertheless, can we have a copy, which is easy enough to get off Westlaw or somewhere,
Yes.
as it stood at whatever you read the material date is? I would have thought that is the date of the judge's judgment,
Yes.
rather than the date of the claim form.
Absolutely.
Yeah. Okay.
Yes.
Okay, but for the moment, for the points you're making, it doesn't make any difference.
Yeah.
Still, we like the right version. Okay, thank you.
It's just that you'll hear from a learned friend, but the court below proceeded on the basis that the power to issue e-visa to those who are on Section 3C leave is the 1971 Act. You may or may not hear a submission in due course that it's the 2007 Act, but in my submission it's not. It is certainly the 1971 Act.
Okay.
Have you finished with the regulations?
Yes.
Where do we see reference to the e-visa in the regulations, apart from in the definition section? I've spotted it in section 13A4.
Yes. Yes. Yeah, it's section. It's also in section 13.2. A biometric immigration document.
Yes.
It has the same language as the provision that my lord has highlighted. That a biometric immigration document begins to have effect on the date of issue, or later, the date on which leave to remain is specified in an e-visa has effect.
So where was my lord's other reference?
13A4 on page 25 and 13.2 on page 23. So the biometric immigration document,
Yes.
in each case, begins to have effect on the date of issue,
Yeah.
or if later,
Yes.
the date on which the leave to enter or remain specified, the date on which the leave to enter or remain
Yes.
specified in the e-visa has effect.
Yes. So in the usual course of events, both documents are to be issued at the same time. But this, in my submission, simply contemplates a possibility that those documents would be made available at different points in time. And there may well be a gap of a day or so or a week between the two documents. And if so, the biometric immigration document takes effect on the date that is specified in an e-visa.
Sorry. And somewhere there must be provision saying what the effect of a biometric immigration document is. I see what the content is, 15.
Yes.
I mean, for all practice, I haven't, not sure I've ever seen one. I've probably seen photos of them in cases, but they are typically, I appreciate they can be any form. There was a time when they were basically like credit cards, weren't
Yes.
they? Like driving licenses.
Yes.
And what were they for? In what circumstances were they used or deployed?
Yes, so that is in the regulations.
Do they have some formal evidential status, for example?
Yes, so regulation 9, which you have at page 20. I'm not sure if that would answer the question, but that concerns use and retention of the biometric information. The Secretary of State can use the information for these purposes.
It's more about the information. Now, I'm being very basic about this.
So
This whole system is set up really because the Secretary of State thinks it'd be a good idea, but fair enough. That's what Secretary of State's there for. You would expect somewhere for there to be a provision saying that the material in a biometric immigration document shall be treated as conclusive proof or prima facie proof of this, that, or the other. No, it doesn't. There's no provision saying what they're for.
No.
Well, Regulation 21.
9.
So, Regulation 21 requires the holder of biometric immigration documents to provide it to an immigration officer or to the Secretary of State.
Yes, I see.
In various circumstances.
Yes. Now, I mean, in the real world, of course, I can understand.
Yes.
In broad terms, it's a very useful thing for to have and to check people are who they say they are and make all the rest of it. But there's no authoritative statement of that in one place.
No, if you're looking for a provision that says that, well, that is to be taken as conclusive evidence of grant, then
yes, or yeah.
I mean, there can be obvious difficulties with having that provision.
Yes, I'm not. Don't worry. I'm not criticising anyone or saying there ought to be. I'm just trying to understand the formal status and purpose of these documents. But it may well be that they aren't stated in one place. You just infer them from common sense and from the specific provisions, like the one my lady referred us to.
Yes, probably not very different from a person having a driving license. I mean, that does not necessarily.
Well, it's a bit different, but because the purpose of a driving license, it is actually the license. That's my point. Well, it's part of my point. I think, I haven't ever looked at the Road Traffic Acts, but I dare say they say you may not drive a car unless you have a license, and that this is the license you have to have. Biometric document isn't quite like that. There's nowhere saying you cannot be in this country unless you have a biometric immigration document.
What I meant was that a person may have a driving license card, but he may well be disqualified from driving. But that person may still retain.
Oh well, that's
that
a different.
card.
That's a different point, obviously. Yes.
So precisely in the same way, a person may well have a biometric card saying that you have leave to remain until 2028,
and it may have been cancelled.
Yes.
Yes. No. I see that. I mean, although it looks a lot more interesting and sophisticated than a piece of paper, it actually has the same defect.
Yes.
Because, as my lord was pointing out earlier, it's not updatable in real time.
Yes.
And the same's true with a visa and a passport.
Yes, indeed.
You might have had a letter curtailing your visa, but unless the Secretary of State holds your passport,
yes.
He doesn't. You can go on showing it to people, and they won't be any the wiser. Yeah.
So this is the 2007 Act and the regulations. What you get is there is no bar whatsoever under the Act or the regulations to grant e-visa or to have an e-visa to those who are on Section 3C leave. And it is certainly not the purpose or the scheme of this that there should be an e-visa for those who are on Section 3C leave. So that's 2007 Act. You then have the 2014 Act behind tab 9 of this bundle. Now, I'm not going to take you to each and every provision that you have behind tab 9. These provisions are about, as you'll see from the list in the index, residential tenancies, bank accounts, work, driving licenses.
Well, we haven't got the index. Oh, I see, the index to the bundle. Yes, I see. Yes, thank you. Yep.
Yes.
Sorry.
So you have these provisions there.
Yeah.
But what is absolutely So the three short points that I'll make about these provisions, rather than taking you through them. The first is that there is simply nothing in these provisions that provides a discretion to the Secretary of State or a power to the Secretary of State to issue e-visa. The purpose, as the court has repeatedly said, the second point, the purpose of these provisions, or our purpose of these provisions, is to discourage overstaying and illegal residence in the country. And third, the offences and obligations that you have under the 2014 Act are not strict liability offences or strict liability obligations. So a landlord or an employer is not liable as long as, I'm just making things as simple as possible, as long as they have complied with the prescribed requirements, they've conducted their checks. And I'll take you to the evidence that deals directly with that. These are the sort of three short points that I make about these provisions.
So the checking system, the one which the claimants say is inadequate, but the checking system was introduced as an integral part of the hostile environment legislation. Is that right?
Well, no, because I mean, of course, that is the 2014 Act. The concept of digitalization.
No,
yes.
I'm not talking about digitalization. I'm talking about the system that exists.
The analog system that exists.
Yes.
Alongside it.
Yes.
Or before it.
Yes.
The government appreciated that it would be wrong to introduce this system.
Yes.
Sorry, to introduce these suite of consequences of being here illegally, unless landlords and employers were able to check whether someone was here illegally or not.
Yes.
And so, as part of there was never a time when the hostile environment provisions were in place when the people on whom they bit could not get an authoritative account.
Absolutely.
It's just it took longer.
Yes.
And was, like all bureaucracies, sometimes much longer than it should.
Yes. So, Lord is absolutely right. So, but that is not only the view that the government took, that is the view that Parliament took.
Yes.
When Parliament decided not to make these strict liability offences or obligations, and there are provisions within these provisions providing defences to the employer. So as long as I said you've conducted your checks, you've complied with the prescribed requirement, that operates as a defence. So I've shown you, my lady, my lords, the 1971 Act, I've shown you the 2007 Act, and I've shown you the 2014 Act. And just to give you a very brief summary in 5 points as to what one gets from an analysis of these provisions.
Hang on 1 second.
So there's no reference to e-visa. The only reference to e-visa is in the regulation, the amended regulation.
Yeah.
And that amendment was introduced this year, wasn't it?
2021, I think you said. Oh, that's a good point.
If you go back, sorry, I didn't.
So the e-visa amendment was in this year.
Yes, it did. So if we go back to I asked you where it was. Do you remember I was having difficulty finding it?
Yeah.
And you told me it was in 13.2.
Yes.
And 13.2 is F49, words inserted by the 2025 regulation. Yes. And the same date, the same regulation is provided in the definition section earlier on in the regulation. Was there anything referring to e-visas under any previous amendment regulations? So this all postdates the judge's hearing, is that right?
Unless I've missed something completely. There's just one provision that in fairness, given that you've asked this question, that I think I'll take you to, that was in existence at the time of the judge's decision. That is section 15 of the 2007 Act. You have that, I've made that point already when I showed you the relevant provision. Section 15 is in the second supplementary bundle, which defines a document. So if you look at tab 4, so this is...
And tab 5, I see, is the regulations which amended.
Yes, amended, yeah.
The regulations we've just been looking at.
Yes. If you look at tab 4, Lord, given that you asked a question as to what was...
Thank you.
Behind tab 4, you have section 15, which says, for the purpose of section 5, which, as I said, is not about grant of leave, but biometrics. The document includes a card or sticker or any other method of recording information, that is biometric information, whether in writing or by use of electronic or other technology or by a combination of methods.
So you would say that that included what we've seen referred to elsewhere as an online record, because an online record is a method of recording information.
Biometric information.
Well, I know, but
yes.
that happened to be biometric. But
yes. Yes. But this isn't about e-visa.
No, I understand that, but
yes.
That would include an e-visa, wouldn't it?
So yeah, you'll hear from a learned friend that may or may not include e-visas. But
what do you say?
It doesn't.
It does not.
It does not. No, because I've shown you section 5, which isn't about grant of leave to remain. Section 5 is about recording biometric information, and that information can be recorded in a document or electronically.
yes, but sorry. Okay, I just want to be. Can I just put it back to you in my own word, make sure I've understood it? Simply reading D by itself, an online record of something,
Yes.
would be within the definition of document.
Yes.
However, this is a definition only for the purposes of section 5,
That's it.
and section 5 is not relevant for our purposes, you say.
Yes.
Yep, okay.
So then that isn't e-visa. And e-visa just comes out of the blue, as it were. Is this right? With the 2025 amendment regulations?
Unless I've missed something completely, yes, that is right. So the first reference
Well, we could be fairly sure.
to the
And
legislation.
were the 2008 regs before the judge, in
Yeah.
the bundle before the judge? And by definition, they were not in this form.
Yeah. So
They were in an earlier form.
First
Well, yes.
reference, yeah.
Unless there was an earlier amendment regulation which did refer to e-visas.
Seems unlikely.
So the first time you
Yes, maybe not.
the phrase was defined in the legislation is.
I mean, the judge's judgment is very comprehensive. Does he actually quote from the 2008 regs in the form they were then?
I'll take you, Lord, to that judgment.
We'll do it later. We don't want to get trapped. But
I notice in the bundle that we've now got, because I hadn't had a chance to consider it in any great detail, the supplementary authorities bundle, we have explanatory memorandum to the amendment regulations.
Yes.
Is there anything in that which might help us? I see a section headed policy context,
Yes.
for example.
In my submission, no. I mean, it's just that this obviously postdates judge's decision, and I just do not want. I do not want to take my Lord's time by taking you to something that isn't relevant for the purpose of the argument that I'm.
No, I see that, but this is all about e-visas, and I think we do need to understand the history of e-visas formally, and Mr. Wright, in his is he called Wright, in his rather exiguous witness statement, does tell us a bit about the history. I don't think he sets out the legislative background. I'm afraid read it rather briefly, but
Yes.
Your point is that at the time of the judge's judgment, e-visas were just part of the ancillary incidental processes which the Secretary of State was exercising
Yes.
as anticipated by Lord Assumption.
Yes.
And it's now become the subject of articulation in the regulations, but it wasn't before the time before the judge, or the time of the matters with which these proceedings are concerned.
Yes. And it's not relevant to the grounds that I'm seeking to pursue. Yes, but if you
Relevant either way, either to the grounds or against the grounds.
Well, we'll hear Ms Harrison, but I think
yes.
it just we'll obviously be going into tomorrow. But ideally, I think we would like to have the regs in their relevant form over lunch.
Yes.
But once we've got at least somewhere into Ms Harrison's submissions, we'll probably have a better idea of how she puts it.
Yes. Yes. I mean,
without steering you away from that, if the law will permit me,
Of course.
I have now cast an eye over the policy, the section headed policy context.
Yeah.
Would that help us just to have a quick look at that?
yes, but the reason why I was sort of reluctant to do this is because of course we'll
I mean, it's the Secretary of State's policy context, presumably.
Yes, but this is looking at this document is going to trigger a series of questions, I'm sure. Yes, so if you look at the documents,
if I promise to keep quiet, Mr. Malik, would you let us look at it?
So page 18, you'll see what was the previous policy. How is this different? If you wish to see a sort of summary of what.
Well, as we're here, let's look at it. But we do it very much subject to a health warning.
Yeah. So 5.14 in November 2024.
Sorry, no, I think actually what would help us most, by all means take us to some bits. I would like to skim read the whole of 5, which will take a minute or two.
Oh, absolutely. Yeah. Great.
I'm actually just going to read 6 as well. I don't know. I have only skim read it, but I found it helpful.
Yes.
But it appears to be the case, just as my lord said, that the 2025 regs are being presented to Parliament, no doubt correctly, as the first time that what they call e-visas have been the subject of legislation.
Yes.
Up to this, it records as a matter of history that they have nevertheless been being issued.
Yes.
And I think it's a red herring for us to consider exactly how, when they were issued, they related to the existing 2008 regs or any other regs.
Yes.
But they were issued under, and you say they were issued under what we'll call for short assumption powers.
Yes. Yes. Yes.
And that's really the end of it.
Yes. So yes. Yes. There were, of course, references to e-visas in different policy documents and the online information on the government's website, etc. But Malord, you have that is my.
Okay,
my
hang on one second. Yes, thank you.
Yes, so just a summary of what, in my special submission, one gets from an analysis of these statutory provisions. It's 5 points. One, there are fundamental differences between Section 3 leave and Section 3C leave. Second, there is no statutory provision that expressly confers a discretion on the Secretary of State to issue e-visa in general or to those who are on Section 3C leave in particular. The third, the power to issue e-visa arises under the incidental administrative powers implicit in the 1971 Act. Fourth, it is not the overriding policy.
Hang on 1 second, sorry. Sorry, fourth again, it is not.
It is not the overriding policy of the 1971 Act, the 2007 Act, or the 2014 Act that those who are on Section 3C leave should be issued with e-visa. And finally, the Secretary of State does not thwart or act inconsistently with any legislative policy, let alone an overriding legislative policy, when she does not issue e-visa to those who are on Section 3C leave.
Is issue the right verb? You issue an e-visa, do you?
It's on reflection, it's probably not.
I think to be
but
fair, you do grant a visa.
Yes, you yes.
I'm not sure. What do we do in the old language? What did you talked about grant? People did talk about issuing a visa, didn't they?
Yes.
Sorry, I disagree with my lord.
No, but I'm just wondering if that's how. Of course,
Yes.
you issue a visa. Commonly understood is a thing that you're issued. Is that what the e-visa is? If it's a digital record?
Yeah. So by issuing, I mean making something available publicly online. So issuing the information online. Probably it's the correct verb would be making available the.
Well, perhaps there's two things, aren't there? And it depends exactly how it's set up, which we don't really have to look at. But conceptually, if you are using e-visas, to use a neutral term, if you're using an e-visa, you're actually doing two things. In old-fashioned language, you're issuing a visa because you're issuing leave to remain, or granting leave to remain to the person who is the subject of it. But, and this is the feature of the e-visa, you are making that information available online in a on an ongoing basis, so that it's always up to date.
Yes.
And that is a completely new thing, for which the verb obviously isn't issuing and is more in terms of making availability. But an e-visa has those two aspects. It is still the old-fashioned, here's your leave, but it is also, and we are making it demonstrable to you at any time and to all the world at any time.
Yes, I mean, of course, so far as Section 3 leave is concerned, of course, Secretary of State has and can also make available information online when someone is on Section 3C leave. So when it is relevant to Section 3C, it's not the Secretary of State issuing leave. It is the Secretary of State.
Now I see what you mean. I see what you. But that wouldn't be an e-visa. I mean, in fact, logically, what the claimants are asking for, consistently with the nature of 3C leave, is not an e-visa, but an e-record. I don't know I can't remember what word is used in the declaration, but
e-visa is e-record of a person's immigration status.
yes, but the distinction that you were helpfully just making,
Yes.
an e-visa issued to someone on Section 3 leave has a dual purpose, I'm suggesting.
Yes. Yes.
Whereas, this was, I thought, your point,
Yes.
someone on 3C leave, strictly speaking, it's only the second purpose.
Yes.
The leave is created by operation of law and doesn't need a visa of any kind. But what we're calling the e-visa, what the claimants want, would be supply the second element, namely the demonstrability.
Yes.
And to be fair, they don't use the term. The declaration is not about e-visa, it's about a digital document proving the lawful immigration status.
Yes.
So we had to be aware of using e-visa as a shorthand for that very reason.
Yes.
Yeah.
I mean, by a digital document, obviously what the judge meant is a document that reflects someone's immigration status in
real time. Yes.
As opposed to a digital document that is simply an email, for example.
Yes, no. I understand that, but I'm just making a note. E-visa as a shorthand
Yes.
for what claimants want
Yes.
is not accurate because under 3C you don't need a visa in the strict sense.
Yes.
You don't need get a visa. What they want is an online record.
Yes.
Confusing name, e-visa.
It is.
I mean,
Well, it's confusing if we use it in the wrong way. Yes, it may still be perfectly appropriate for a 3C visa, for a Section 3 visa.
it's all summarised in the first sentence of 5.2 of the policy context document as to what it is. They stopped issuing physical biometric residence permits and instead provided foreign nationals with online evidence of their immigration status through e-visas, which holders can view and share with third parties. I'm sorry to say, I think this might be quite relevant to the respondent's case, which is why I've sort of put the brakes on and distracted you. Anyway, I think we've covered it. Thank you very much.
Yeah, it's been very helpful.
So you have a summary of the 5 points that I've made, and for these reasons I submit that there is no breach of Padfield principle, and these 5 points will in my submission inform the court's decision on how to approach Wednesbury. So I'll move on now, subject to any observations, to Wednesbury principle. The judge, as the court knows, refers to a number of different authorities on the subject. There are 3 authorities that I will need to take the court to in order to address the reasoning given in the judgment below, and I'll do so very quickly. The first is RM versus Scottish ministers. It's tab 5 of the core authorities bundle. So this is a case where the Supreme Court considers a challenge to the failure of Scottish ministers to make regulations under the Mental Health Scotland Act 2003. The statute, unlike the territory that we are in, conferred a discretion, a power to make regulations, and it was said that the failure to make regulations was inconsistent with the scheme of the Act. The paragraph that you will look at in my respective submission are paragraphs paragraph 47, right at the end, last page of the tab, page 124. Of course, this concerns Padfield, but the judge used it in support of his analysis of the Wednesbury principle. Even where a statute confers a discretionary power, the failure to exercise the power will be unlawful if it is contrary to Parliament's intention. That intention may be to create legal rights which can only be made effective if the power is exercised. So what legal right the court will consider? Section 3C intended to create. At its highest, the legal right that Section 3C intended to create was protection from being an overstayer. If the Secretary of State makes a rule or a regulation that makes a person on Section 3C leave an overstayer, that could be unlawful for being inconsistent with the scheme of that act. But there is no legal right under Section 3C to have a notice in writing or a digital document.
These are, I'm not criticizing you, these are the points you've made already.
I have, yes.
No, I just wanted to make sure I wasn't missing something.
Yeah. It's just that I'll take you to these three authorities which the judge has used in support of the analysis, and paragraph 47 is the paragraph that he highlighted, and that is my answer to that paragraph. The second authority is one that court is familiar with, the judgment in Johnson.
Yes.
Tab 8 of the authorities bundle. If you look at paragraph 6 of that judgment, you'll see the relevant legislation. So unlike the territory that we are in, the Act, the primary legislation, provided a power to the Secretary of State, an express power to make regulations. And as the court knows, the dispute in that case arose because the system of identifying the income earned by a person who were usually paid on a particular day of each month, such as the last day, would in fact be paid on a different date. And it was in that statutory context, you will, in my respectful submission, consider what is said at paragraph 50 of the judgment, paragraph that the judge highlighted, judge deployed in support of his analysis. So paragraph 50 is where the court identified certain questions that were considered, namely, well, what are the advantages of doing X, what are the disadvantages of doing Y, and whether a reasonable balance has been struck. This again is in the context of an express statutory power requiring the Secretary of State to do X or Y. In my submission, these questions, this approach does not apply when the court is considering the exercise of incidental administrative powers that are implicit in the piece of primary legislation.
Yeah.
Finally, the last judgment is this court's judgment in Pantelacero.
Pantelacero.
Sorry, I will not even try it again. So it's in the supplementary authorities tab 27. This is the judgment of my lord, the Vice President. Go to page 824. You'll see a heading, the test of irrationality. And my lord noted that in Johnson there was no detailed discussion or submissions on test of irrationality. But then the test that was used was one that was used in Law Society versus Lord Chancellor. whether a decision is so unreasonable that no reasonable authority could ever have come to it, and whether the decision is outside the range of reasonable responses open to the decision maker. So this is the classic formulation that in my submission the court should apply in this case. Paragraph 56, my lord, makes the point in my submission entirely correctly that intensity of the review depends on the context, and common law no longer insists on the uniform application of the rigid test of irrationality in every context. Paragraph 57, my lord, refers to SC, where the point that the Supreme Court made was about the principle of deference. And the court should accord a high level of respect to the judgment of public authorities in their specialist field. Of course, that would apply here with equal potency. Then paragraph 58, Lord quotes from an earlier authority where it was said that where a statute confers a power and it can only take effect with the approval of the House of Commons, it may not be open to challenge on the grounds of irrationality, short of the extremes of bad faith, improper motive, or manifest absurdity. I appreciate, of course, that we're not in that territory, but in my respectful submission, where the argument is that the Secretary of State has exercised the incidental administrative powers in an irrational way, then a fairly high threshold applies, the sort of threshold in my respectful submission that is there.
The other thing, I'm not sure what point, I'll just really make this point in case either counsel wants to make observations about it. Although obviously the particular issue was different, this was another case where the government had put in place a system the system didn't work. The system produced anomalous effects in a small but real number of cases, which was recognised and which the government was thinking about and was under review to see whether they could tweak the system so as to remove that problem. And we had to address whether the fact, as it were, that there were acknowledged imperfections in the system meant that it was necessarily unlawful. And that's really the point that I addressed in para 90 of my judgment. And as far as it goes, it's a point that I think assists you, that a system that has imperfections isn't unlawful just for that reason. It may be unlawful if steps that are taken to improve it, which are available. Well, but sorry, if it is clear there are steps that could be taken to improve it, and they are not taken, irrationally not taken. But that depends on the facts and circumstances of the particular case. As you can tell, I haven't quite thought how this point is relevant or to the extent to which it applies here, but since we're looking at Pantellerisco, it's one of the respects in which none of these cases are very close to our case, to tell you the truth, and I think I would want to deprecate, you haven't done this so far, looking at cases just to see for broad similarities. But in that respect, there is some analogy with our case.
So the reason why I took you to these three authorities is not to rely on them, but to demonstrate that these three cases are different.
Yes, I see.
From the case, because in that instance, the respondents rely on these authorities, the judge has relied on them. These cases are, with respect, fundamentally different.
Yeah.
But, my Lord, I'm grateful. Yes. So the point that my Lord makes is a valid point, that where steps are available and the Secretary of State irrationally decides not to take those steps, then that could give rise to a challenge.
And that was the facts in Johnson. Yeah.
Yes.
Yeah.
But surely, I think this is the point that my Lord was making. But surely it is not, with the greatest of respect, it's not the task of the court to decide what steps should or should not be taken.
And over what timescale?
Yes. And what is more convenient and appropriate and what is not. The task of the court is whether there are steps that the Secretary of State has irrationally not taken, rather than substituting its own view as to the merits of those steps. So, my Lord, these are three authorities that I wanted to take you to simply demonstrate that the cases are different. Then, just moving on, my Lords, to the evidence. Now, when the 2014 Act was introduced and the measures were put in place, as my Lord the Vice President noted earlier this morning, that the government took the view that there ought to be facilities for the employers and landlords to check the person's immigration status. There are three things that the Secretary of State did. First, the Secretary of State issued guidance to employers and landlords. Along with that guidance, the Secretary of State issued codes on discrimination, essentially assisting the employers and landlords to ensure that there is no unlawful discrimination. Second, the Secretary of State set up an online checking service. This isn't e-visa, an online checking service for employers and landlords that enabled employers and landlords to check a person's immigration status online, but that did not contain real-time information.
Sorry, didn't have real-time.
Real-time information, and the responses, and the Secretary of State the service would take 2 days to 5 days to provide that information.
When we say it's online, it's online in a completely different sense from e-visa. You basically go to a site and raise a question, and then you wait to get an answer.
Yes.
Yeah.
So, and you'll get an answer within 5 days.
Is that a target or a?
No, that was the time frame, and the evidence to which I'll take you to demonstrates that was working within that time frame. And thirdly, the Secretary of State set up a telephone line to assist employers and landlords. So if an employer and landlord has a question, they can telephone the helpline, and someone would assist as to their obligations and how to protect the system. Now the evidential basis.
Sorry, but that's not an alternative to 2. You couldn't use the telephone helpline to say, I've got Mr. Jones in front of me here, and he says he has Section 3C status. Can you tell me the answer? Well, that wasn't what it was for.
No. And then, yes, you can raise that question over telephone. In all likelihood, the person on the other side would tell the person that, well, you go to this website.
Yes, I see what you mean, yes.
You do X, Y, and Z, and you'll get the information. There are 2 witness statements that, lady and lords, you have seen, I'm sure, from Jonathan Wright in the supplementary hearing bundle. Page 1, you have Ms. Wright's first witness statement.
Sorry, this is, I admit at once, completely irrelevant, but it's very odd. He and other people seem to say this a lot in government witness statements now. I prepared this statement using remote working software. What does that mean? Does that mean anything more than I used my computer, or does it mean something that we ought to know about?
I think it means nothing more than.
I'm sure it's not significant.
Nothing more than that.
It wasn't a chatbot.
Well, exactly. I mean, I'm quite sure it doesn't mean I use ChatGPT, but all the same, it's an odd phrase. Perhaps you could just ask over lunch what it does.
It might have meant using. We shouldn't be. We shouldn't throw up our hands in horror. The idea that artificial intelligence might have been used to assist in the drafting of this document.
Well, I would like, if that is really what it means, to know more about it. I suspect it doesn't mean that, but
I'll get an answer.
could you? Yes, thank you.
Good.
Anyway, that wasn't what you were taking as.
Yeah. So this is the statement. Paragraph 3, Mr. Wright makes a point, a valid point, that it's just not possible to provide a meaningful physical document confirming a person's Section 3C status. That would also apply to a digital document that is not a real-time document.
Well, I think the judge so found, and that's now accepted on this appeal. This appeal is all about digital online records of the kinds we've identified.
So paragraph 4, I will not take you to guidance documents and codes, etc. How they operate is at paragraph 4. So this is evidence about the guidance that is issued to the employers and landlords, and the codes designed to avoid unlawful discrimination when undertaking checks.
Did I imagine it, or was there litigation challenging this guidance on the basis it was self-discriminatory? I think it didn't succeed.
Yes.
There was. But it never came to this court.
It did, I think, yes.
But it didn't succeed.
Yes.
What? Just for my note, what was the name? If you have it in your head, you can tell me. If not, you can tell me up.
Yes, that was the challenge by Liberty. I think I'll get you.
If you could guess the reference.
Yes.
Thank you.
Yes. So that's guidance, paragraph 4. The online checking service is paragraph 5, how that service works. And the aim of the service was to provide a response within 5 working days. And you'll see how the system works. And a document is issued that is valid for 6 months. But that does not mean that the person has leave for 6 months. It simply provides a defense to the employer for 6 months.
Yes, so in fact the online checking service would Well, by definition, it would only say, yes, the decision has not yet been
Yes.
made. And then it might, in practice, be the application might be rejected the next day.
Yeah.
But the employer would be in the clear for the next 6 months.
Absolutely. Yeah. And then right to rent, you get a positive right to rent notice if the result is positive, and you get the aim is to get the result within 2 working days. And where that aim is not met, then you get an automated response confirming that that is an automatic statutory excuse. You'll either get an outcome in 2 days or a confirmation that, well, this is your defense, that is valid for 12 months. And last sentence of paragraph 5, this is the third step that the Secretary of State took. There is an inquiry helpline, and they can call for support and advice if they need assistance. Paragraphs 6 to 9 is summary of how NHS operates and why those who are on Section 3C leave are able to access health services. So the Secretary of State, after setting up these steps, considering the legislation concerning NHS, decided whether that was enough, and you have evidence about that at paragraph 10. And the Secretary of State, which writes that considers it appropriate not to issue physical status documents to those who are on Section 3C leave.
These are all points you've made.
Yes, and then paragraph 11 and 12 are about Section 55 guidance and the equality statements, and then of course you have looked at the explanatory notes to the biometric regulations. But if you wish to see a sort of succinct summary of how the system developed, that is at paragraph 13. So the Secretary of State decided to issue e-visas, not because she felt that there was some obligation under the legislation for her to do so, but because that was consistent with the government's long-term vision to do things digitally. And that sort of paragraph sets out what the Secretary of State had in mind as to how Secretary of State would digitalize things sequentially in a gradual manner. Then right at the end of that paragraph makes an important point that, well, we cannot really do this retrospectively. So if someone has made a non-digital application or a paper application, and that person is on Section 3C leave, Secretary of State cannot sort of retrospectively issue an e-visa to that person. So the way in which the intention was that the Secretary of State would gradually, route by route, require applicants to make digital applications for further leave to remain. Applicants would be granted e-visas on those digital applications. And when they would apply in due course for further leave to remain, they would already have these e-visas. And Section 3C would be reflected on that. I do apologise for doing this.
No, if you were picking up mileage at the clock, that wasn't in any way critical.
Just one further point I should have emphasised when I was showing you paragraph 10. The Secretary of State, this is in my submission important. The ultimate conclusion, the judgment that the Secretary of State exercises is that those whose leave to remain have been extended under Section 3C face no such prejudice as to require the Secretary of State to act differently. That is the Secretary of State's view. It is open to a person who applies for further leave to remain to seek, in certain circumstances, a faster decision. They can apply to get a decision within 5 working days or by the end of next working day by paying a fee. These are various competing considerations that the Secretary of State took into account.
So there's two rates. There's a figure you had to pay for 5 working days and a higher figure you had to pay for next working day.
Yes.
Yeah, okay.
When the paragraph says, Mr. Wright says, no such prejudice.
Yes.
What is he referring to?
The risk of unlawful discrimination.
Where does it say that in the paragraph? No such prejudice. Such prejudice implies something referred to previously in the statement.
Yes.
Oh, I thought no. I thought such didn't mean such in that sense. I thought it went such as to require them to act differently.
Yeah.
Oh, I see.
Yes.
No prejudice such as to require them to act differently. Okay.
But
yes.
I didn't read the evidence or the judgment as being focused only on unlawful discrimination, though that may be part of it. It's prejudice just in the general sense that sometimes you can't afford to wait while the checks are done, because not so much you can't afford to wait, but if anyone knows who's tried to rent property in London, landlords get bombarded with offers, and they'll take the offer that's easiest to deal with, and they won't wait 2 days to get a response from the checking service. So that's prejudice in the sense you haven't got the accommodation you wanted. I'm right, isn't it? Certainly you appreciate, it's not quite clear what the Secretary of State appreciates, that the prejudice being complained of is that kind of prejudice and equivalent in job offers.
Yes. So, absolutely. So, I, of course, entirely accept that people do face difficulties if they do not have evidence to demonstrate their status immediately. The Secretary of State, in my submission, the evidence shows, appreciates that, but then says that, well, I've taken these 3 steps.
Yes.
I have, you can get a quicker decision if you want. I've balanced everything up, and I don't think that...
well, I think it does say that. It says it in a single sentence. But... well, I'm not going to make Ms Harrison's points for her. She will make them. There isn't what you might call a grappling with the claimant's evidence. There's simply a general statement that I'm aware of these problems, but I'm looking at them in the round and having regard to the mitigating measures I've taken, that strikes the balance satisfactorily.
Yes. But of course, you will not look at that paragraph in isolation. He then,
no, I understand.
They then, of course, explain that, well, there is this long-term vision, and we are in process of just digitalizing everything in a gradual manner on a route-to-route basis. And we'll ultimately get
in a way, I'm not sure this is the way the case was put against you, in which case it's not surprising it wasn't dealt with. The way the case is refined as it's come up, it's really, doesn't it come down simply to this, that the availability of a digital online record for 3C people should have been introduced now or already by the time of the claim, and not as something that will happen gradually in the future.
Yes.
It's all about timing.
It is.
And there's nothing from the Secretary of State saying, well, I couldn't have done any sooner because the technology wasn't there, or this all takes time to plan, or whatever it may be. But I'm not entirely sure it's clear that that was really what the case was. So I'm neutral about that. But your evidence does not say anywhere this is why we have introduced the 3C scheme now and why we didn't introduce it earlier and why it's taking many years to do. Is that fair?
That is fair. Yes. Save as to the paragraph, of course, that you have read, paragraph 12. Paragraph
13. Yes, there are some generalities there. There's the particular point you make that.
Yes, and the last sentence of paragraph 13 in particular, that just cannot be done retrospectively. So if someone has made a paper application and that person is on section 3C leave, we cannot just create an e-visa for them.
Now, I see that, but I suppose the answer to that would be if you started 5 years earlier, that would have worked its way through by now.
Yes, but of course the ultimate question is whether that means that there is a public law obligation.
Well, I know. I take that.
Can I just, in this 2 minutes that we have, just show you the second witness statement?
Yes.
Which you have at page 7. And if you look at page 8, you'll see that Mr. Wright checked the position with the colleagues, and the ECS system was providing responses within 5 working days, and it was responding well within the time frame. So that was his evidence. He then explains what he meant when he said that the Secretary of State does not consider there to be a real risk that those who have applied for further leave to remain would be treated as being unlawfully present in the UK. He says that is the Secretary of State's view, and whether that is a rational view is a question for the court.
So, when he says in the previous statement, no prejudice such as to require to be treated differently, he relies on, Secretary of State relies on these alternative systems in place because the delay, the minute 5 working days in the circumstances, the Secretary of State's cases, that shows there's no prejudice. So that depends, doesn't it, to some extent, on the evidence the other way.
Yes.
Yep. And do you accept that the digital record has changed the landscape? So this is the claimant's case, has changed the landscape, so that decisions are now made by landlords, employers, health service, certain landlords, employers, on the basis of a digital record.
Yes.
Sometimes.
Yes.
I mean, certainly at the time of the judge's decision, we don't have any up-to-date evidence, rightly. Time of the judge's decision. Most cases were still not being dealt with digitally.
That's right. Yes. Yes. The judge asked that question. We provided that information afterwards as to the routes. Yes. That is right. Yes. So it's paragraph 4 where Mr. Wright in that statement sets out the routes where e-visas were available, and there were of course many other routes at the time. So those were the routes where a person would receive an e-visa if the person makes a digital application. And when a person has e-visa, they then apply for further leave to remain, they would be able to see their section 3C leave in real time.
Yes, so there's a delayed effect, isn't there? I mean, have I understood this correctly? You apply under that route, and you get it.
Yeah.
The question of 3C then won't arise for another 2 years.
That's right, yes.
Or depending how long the visa is, maybe 5 years. And at that point,
Yes.
You will simply look at the e-visa, which will say something like expired, but application made for extension, which is still pending.
Absolutely.
Yes.
And the reason why Secretary of State, and of course, there is this broader principle why the Secretary of State is defending the appeal, but the sort of practical reason is to address the cohort of cases where a non-digital application is made.
Yes.
Where
Which you said to go on, and again, rightly, we don't know. We know that the evidence in front of the judge was that it would extend to all new applications until by the end of 2025. We don't know whether that's been achieved.
No. Yes. You don't.
So you weren't allowed to tell us, but.
I mean, my lady.
No, I'm not getting it. I think my lady was clearly, if I may say so, her answer was clearly, her refusal was clearly principled and correct.
Absolutely.
But the fact is we don't know. And that, whether it was achieved or not, there was still a problem.
Yeah.
And the question is whether the problem was unlawful.
Yes.
Yeah. Right, we run on slightly. That's a good moment to stop.
Very good.
Roughly how long do you think you're going to be? You've probably gone slower than you wanted. You've been interrupted
yes,
by us.
Another 30, 45 minutes.
Yeah.
I'm just rising because we've been able to obtain those previous regulations. So I'm not suggesting you have to read them over lunchtime, but I can give them.
And you've even got 3 copies. That's very good.
Yes.
Right, well, we'll have them now. Thank you very much for whoever did that. So this is, just so I can mark it up, this is the version that was in force at the time of the judge's judgment.
Yes, my lord.
Well, one less. You have less support behind you.
Yeah.
Mr. Malik. Perhaps we have people watching remotely, using remote software, possibly. Right. 2:05.